Rescinding a job offer can have serious legal implications for employers. Understanding when and how to properly withdraw an employment offer is crucial for avoiding costly lawsuits and reputational damage. To define the term, rescinding a job offer means withdrawing an employment offer that has already been extended to a candidate. This action can occur either before or after the candidate has accepted the position. Employers can legally rescind job offers in many situations. Common legitimate reasons include failed background checks, discovery of falsified credentials, budget constraints, or when a candidate stops communicating after receiving an offer. For example, if an applicant doesn't pass a required background check or misses their first day without explanation, rescinding is typically justified. However, timing matters significantly. Rescinding an offer after acceptance carries much greater legal risk. In some jurisdictions, like California, employment is considered to begin upon acceptance of a formal offer, not the actual start date. This means withdrawing the offer could trigger wrongful termination claims rather than simply being viewed as rescinding an offer. Certain reasons for rescinding offers are explicitly unlawful. You cannot withdraw an offer based on discovering that a candidate belongs to a protected class. This includes rescinding because you learn the candidate is pregnant, has a disability, or practices a particular religion. Such actions violate federal anti-discrimination laws and can result in costly lawsuits. To minimize legal exposure, employers should implement several best practices. First, use conditional language in all job offers. Clearly state that employment is contingent upon specific factors such as background checks, reference verification, or credential validation. Document all requirements that must be met prior to employment, and whenever possible, complete all verification processes before extending a formal offer. When crafting job offers, avoid flowery language that might imply guarantees or promises. Phrases like "for many years" or "flexible scheduling" can create legal gray areas. Similarly, avoid language that suggests a specific time frame of employment, as this could be interpreted as a contract. Include an expiration date for the offer to ensure you receive a timely response. If you must rescind an offer, approach the situation professionally. Act promptly once the decision is made to avoid further inconvenience to the candidate. Always communicate the decision in writing, providing a brief, lawful explanation when appropriate. Express regret and appreciation for the candidate's time and interest. In some cases, you might consider offering to keep their application on file for future opportunities. Before rescinding any offer, especially one that has been accepted, consult with human resources, professionals, or legal counsel. The potential candidate may have legal recourse against your company under the doctrine of promissory estoppel if they suffered damages by relying on your offer, such as resigning from another position or relocating. Rather than immediately rescinding an offer, consider alternatives. You might postpone the start date if the issue is temporary, adjust the role if the original position is no longer available, or clarify expectations if there have been misunderstandings about responsibilities or qualifications. The financial and legal consequences of improperly rescinding an offer can be significant. Beyond potential lawsuits for discrimination or promissory estoppel, your company may face reputational damage that affects future recruiting efforts. Job seekers often share their experiences online, which can harm your employer brand. To summarize, while rescinding job offers is legally permissible in many cases, employers must proceed carefully, especially after a candidate has accepted. Use conditional language in offers, document all requirements clearly, verify information before extending offers, and avoid discriminatory motives. When rescinding is necessary, communicate professionally in writing, and consider consulting legal counsel to ensure compliance with state and federal regulations.